today I wanted to discuss your deeds, how you hold your real property. And Jamaica is similar to New York in such that we have two title holdings that are similar, which are the tenants in common type of ownership. And when you are closing on a property, I am going to want you to revise and take a look at the deed and ensure that your legal ownership is displayed in the manner that you wish to see it. And I will encourage, for those of you who want to be able to leave your property via a will, you can make sure that your ownership is as tenants in common. You'll have children who are expecting to inherit, because when it is that you hold as a tenant in common with someone, you in fact have the right that you can will your property to whomever you want. You can actually sell your interest to whomever you want. When you hold as joint tenants, there is a right of survivorship that comes along with joint tenants with right of survivorship. This is an automatic operation of law where if one person dies, then by operation of law, their portion goes to the person who remains on the deed, right? And what you'll find is when you have people who are manipulative, like you may have children who are very manipulative with regards to their parents as their parents get older. So, what they will do is some of them will see the will that their parent have made, and they may decide that they don't want less of a share. So, what they do instead of just letting things flow by your parents' will get probated and you get their due share under the will, they go ahead, they go and they influence their parent to change the type of ownership. And this is why, as your parents become older, when they have substantial property, you have to watch what is going on. And you know, your siblings who are in fact manipulative, what they will in fact do is encourage their parents to change their deed, put them on the deed, and they want to change the nature of the ownership to joint tenants with the right of survivorship. And what that in fact does is, for the children who are banking to inherit on the deed, because the title was changed prior to death to joint tenants with a right of survivorship, those children who are there waiting in the will can no longer inherit. And that sibling who went ahead, encouraged their parent to, in fact, change the deed, what happens is they now, as the sole survivor, untitled, inherits everything, and the will is of no effect. What you have to understand is when you take your deeds, and if you see joint tenants with the right of survivorship, then it is the person last to die whose will control. So, what you will have some manipulative children, what they will do is they will go, because when they see that their parents are getting frail, they go by the house and they're searching and taking a look at titles. They are taking a look at wills, because this is a way to get closer to the parent when they are in their most fragile state, to take advantage. And I mean, you will definitely know your siblings who are like this. And I would encourage anyone who has made a will, one of the presumption is if you have a will and it was last in your possession, and at the time of your death, they cannot find the will, the presumption is that you destroyed it, right? and as a result of which the rules of intestacy prevail. And dependent on who are your heirs, they are able to benefit. So I'm going to encourage anyone who has a will, leave it with your executor once, of course, it that person is trustworthy. Some people like to actually file their will in surrogate court. This is not something I would recommend, especially when you change your mind. And now the court system is very much aware there was a second will. So you're now serving people with notices who could have inherited under the first will. I would not encourage you to do that. What I think is do not leave that will. You can leave it with your executor, because if you are in fact nominating someone as your executor, what it is in fact doing is that's like a level of trust that you are in fact designating to that person, that you believe this person is trustworthy, and as a result of which you are in fact giving that person the will, so that if you should die, it wasn't lost in your possession. So that presumption that you have revoked your will does not stand. New York goes a little bit further in terms of ownership for real property for husband and wives. If you are in fact married, there is an automatic right of survivorship. And I have had, and I will tell you about the entitlement of your children. It amazes me how your children are so entitled. And upon your demise, your death, if real property in New York is held as husband and wife, then the spouse automatically gets it. But what I have found with your very entitled children is that they believe they should be getting an interest upon the death of one of their parents, regardless that at the time of acquisition or later on in life, the parents somewhat at some point decided that they're going to hold the property as, and the husband and wife ownership is often designated by the word et ox, or you will see his wife. You may see as tenants by the entirety, or you may see that the property is held as husband and wife. So if it is that you have created a will and you hold as husband and wife, and one of the difficulty is for people who have outside children. Here comes the difficulty now, right? Because sometimes you may want your outside child to benefit. But if it is that you are holding as husband and wife, it's not going to happen for you. Or you may even want your children to benefit. If you are not the last to survive and you hold your property as a tenant by the entirety, which is often denoted by, you'll see the names on the deed, and then there's a comma, you'll see his wife, or you'll see as husband and wife. If that's not there, yeah, then it is presumed that you're holding as tenants by the entirety. However, the law is such that oftentimes they're going to divide up the property as tenants in common. If you do in fact hold as tenants by the entirety and you wish to sever this, you have to change your deed. Yeah. And this is where